Hi, everyone. Good evening. Carl Steinbeck here. Going to switch gears tonight and cover the Adelson murder case. A lot of you guys are maybe not familiar with this case. This is involving a doctor family in South Florida that involved the patriarch of the family, Harvey Adelson, who was a dentist, had the Adelson Institute of Dentistry. His son was a periodontist, followed in his footsteps. And they also had a daughter, Wendy Adelson. She became a lawyer, and Wendy wound up marrying another lawyer, FSU law professor Dan Markell, and they wound up settling in Tallahassee, Florida, while the other Adelsons lived in the southern Florida area. So what happened, and the Adelsons also have a son that became a doctor, an MD that lives up in the northeast part of the United States. He was not involved in any of this. He's a very highly esteemed, successful, and honorable person. But the rest of the family down in Florida, they were involved in some stuff that has to do with the elimination of Dan Markell, because Dan would not agree to move the two boys that he had with Wendy when they were still married, to move them to South Florida to be near family there, the Adelson family. So that thing that happened was Charlie Adelson, the son, he wound up using some contacts he had to hire a couple hitmen that went up to Tallahassee and basically gunned down this professor as he's pulling into his driveway and parked in the garage. And two guys came up all the way from South Florida. The trip is like over 7 hours. They drove by car there, put a couple bullets in his head, and then took off. But lo and behold, a couple years later, they eventually found through records involving the travel of the Prius that was rented to drive up there and do this actual execution. They were able to find the hitmen, and through the hitmen, they were able to discover who hired them, which was Charlie Adelson, through a middle person, a girlfriend of his. And lo and behold, eventually, it took many years. Keep in mind, this murder happened in 2014, but we're still over 10 years beyond that point of the murder, and we still only have one Adelson convicted, the periodontist Charlie. So his trial happened in when was it? It's now over a year and a half ago, and so he's pending an appeal. So I want to cover the appeal for him. His mother, Donna Adelson, she's pending trial. She was supposed to go to trial last year, but as it turns out, her lawyer had a conflict because he represented Charlie Adelson in his trial, and Charlie's appellate lawyer wasn't going to allow Charlie to become a witness in this case. So anyway, it's a long thread to unravel, but it's nonetheless a long, crazy, bizarre history of this case. I've been critical about the prosecution not being tough enough on crime and going after other Adelsons on a timely basis. But the thing is, they finally did go after Donna a mere days after Charlie was convicted. So the prosecution is going after one Adelson at a time. Until they get a conviction on one Adelson, they're not going after the next. So there's been a lot of clamoring for Wendy, who a lot of people think is a mastermind behind this whole plot to murder her ex. Should have been charged and convicted by now as well, many years ago. But she has only been named an unindicted co-conspirator. But there's more and more talk now that she's going to be coming up on a indictment here before too long. It's been way overdue. So in any case, she's since also moved to the Austin, Texas area with the two boys. And what was really so cruel, besides just a murder, is the way that Dan Markell's surviving family has suffered with the loss of the majority of any visitation and meaningful relationship they've had with the surviving sons of Dan and Wendy. And so that's something that was really, I thought, so disturbing to see this. Not only did they have parental elimination to have to deal with these two boys, but they also then had basically the entire Adelson family tree cut off. So keep in mind, these two young boys, they've grown almost 11 years since this happened, but they were like 4 and 5, roughly 4 and 5 at the time this happened, the murder happened. And so add almost 11 years to that, but they still have never actually visited their father's gravesite in Canada, nor they visited any family members in Canada since this murder happened. And so that was something that was so incredibly disturbing to me. So it's one of the reasons I agreed to have my brother go on a live stream and cover this case. So over, what was that? It was over 2.5 years ago. So this case is still going on, and they still have more Adelsons to nab and prosecute. But in any event, I just want to circle back to this case. I've been away from it for a while, and so keep in mind they could have done a lot of things, but they could have even had Wendy's parents move up, get a home in Tallahassee. They had millions of dollars in the bank. They had over $8 million of assets. They could have easily bought or rented something in Tallahassee to go visit the grandkids. But shared visitation, shared custody was not an option for the Adelsons. They wanted total control, total elimination of anything Markel, including they eliminated the boys' last names. So imagine these boys had the last name Markel, and then within less than a year after their dad is murdered, the mom changes their last name to her last name. So it was really a cruel effort to cut off the entire family tree. They've really only seen sporadic contact with the surviving parents of Dan Markel, who is Phil and Ruth Markel, and so it's really a tragedy on so many different levels, and the pain and suffering keeps going on. So there is some contact, as I understand, that's sporadic between the grandparents and their Aunt Shelley, who's Dan's sister, and she has 3 kids, I believe it is, and they're all from Canada. So Dan Markel is from Canada, and Wendy was from the Florida area there. So in any event, I want to cover the appeal brief, just go over a few things of that tonight before we cover Donna. So this appeal brief here from Charlie Adelson, keep in mind he was a periodontist. He had his dental degree, and he went on to advanced schooling to get the periodontist designations. And his attorney here is Michael Ufferman. And Michael Ufferman's one of the preeminent appellate lawyers there in Florida. He only does appeal work, and he's there in Tallahassee. So there's not a whole lot to say about this. I'm looking this over, and the main thing they start out with is they're trying to say that Charlie was denied a fair trial because the jury, there was so much publication of this case, he didn't get a fair jury assembly because it was too permeating society there, this murder case. And he goes on to, let's cover some of the areas. Here's a little bit of summary of the case. You can see the state claimed the appellant Adelson hired hitmen Sigfredo Garcia and Luis Rivera through Katie McBanois, who was appellant Adelson's then girlfriend. And I've argued that he basically found this girl after 2 weeks of dating her, asked her if she knew anybody that could do physical harm to somebody else. That was her testimony anyway in court. And see, he basically was grooming her to use her to find somebody to do the killing. And during opening statements, evidence previewed by the prosecution included wiretaps, financial transaction, a money trail on Wendy Adelson's actions post-murder, relocating to South Florida very quickly, and then changing the children's last name. Appellant Adelson's defense disputed this interpretation that explained that Appellant Adelson had not been involved in planning the murder, but had been extorted by killers McBanois, Garcia, and Rivera after the fact. So this is like the most laughable defense theory I've ever heard, which is he planned the murder, and then the hitmen who got busted and pointed the finger at him, at least one of them did, this Garcia. Garcia did not. He contested it and got convicted of first-degree murder, sentenced to life without parole. Same with McBanois, Katie. So Katie McBanois and Sigfredo Garcia, they're not married, but they've had a long-term relationship together, and they have 2 kids together. So now basically both parents are spending life without parole. behind bars. Luis Rivera, he was a Latin Kings gang member. He's the one that drove up there, and he recruited Garcia to go with him, so he didn't have to make that long trip by himself. And the statement from Rivera is that Garcia is the one that actually pulled the trigger. And so you can see here, Dan Markel was shot twice in the head, July 18th, 2014. So we're going on 11 years this July 18th. And he actually died the next day on the 19th. And it says here, Dan and Wendy had been divorced, and even after the divorce was finalized, they continued to have legal disputes regarding parenting, time sharing, financial, and other issues. They talk about the relocation. Wendy's request to relocate by the court was denied. Then emails between Wendy and her mom, Donna, indicated continued desire, at least on the part of Donna, for Wendy and the children to relocate. An email from Donna suggests that Wendy should offer Dan $1 million to allow her to move to South Florida with the children. So they try to bribe him with that. At least that's what they were talking about. Apparently they never sent that to Dan as an offer, but Donna's email suggested the payment would be funded by the Wendy's parents. Is basically a three-way split between Harvey and Donna paying $1/3 Wendy paying $1/3 and then Charlie, her brother, would also pay $1/3. And this sort of goes off then about how the murder happened that morning. The morning of Dan's murder, Markel dropped off his and Wendy's children at the preschool and then went off to the gym. Surveillance from the gym city bus on the location showed a vehicle, light green Prius, following Markel around town that morning. And then based on distinctive features, the vehicle is a sun pass transponder. That's a through their toll system there to charge people for driving on their interstate. That's how they're able to track the vehicle to besides just the plates. Cell phone analyses. Investigators developed a suspect vehicle trace it South Florida. It was rented by Luis Rivera. He actually put his name on the rental car agreement. And also Sigfredo Garcia's phone number was on the rental car agreement. So they both had nicknames of Tuto and Tato, which can be confusing because they're so close. And then it goes on to talk about how the Adelson Institute was a family-owned dental business owned by Harvey and also his son Charlie, the appellant. And they talk about how McBanois, the girlfriend, started receiving payments from the Adelson Institute a couple months after the murder. Check were in batches, sequence multiple right in a row. There was 18 sequential checks. So it looked like she was being paid after the fact for committing a murder. They're just trying to keep it on the down low. And then when the day that Dan Markel was shot, Wendy goes to the police station. She's not read her rights. They pick her up at a restaurant, and she goes to this interview. And you guys need to see that because it's on YouTube if you do Wendy Adelson interview. Some people call it an interrogation, but it wasn't an interrogation. It was only an interview. Anyway, she was there for like 5-6 hours. But she gave a lot of good information. She tried to claim that she didn't know anything about it, but there's a lot of incriminating information about it. And she even said that her family could have been responsible. And the joke was Charlie was saying to Wendy, "I bought you for your divorce present a TV instead of hiring a hitman." So, and wouldn't you know, the morning of the shooting of Dan Markel, a Geek Squad guy was there to fix a TV that had been broken for quite a while. And so it just seemed very much, as you'll see throughout the details of this case, that the code word for the murder was a broken TV. Anyway, I'm not going to get into some of the other key witnesses. There was a Jeff Lacasse. He was also a professor there that had dated Wendy, and it looked like he was to be another option to be either a fall guy or a guy to do the actual hit. It looked like Wendy had groomed him, and he was never seriously considered by Wendy, yet they dated for a while, a number of months. So there's just a lot of crazy interaction with a lot of different people on this case. And there it talks about how Luis Rivera was the head of the Latin Kings gang in North Miami Beach. He actually cut a deal and got a 19-year prison sentence. And I think in about 3 weeks, he's going to be released from his federal sentence and be serving the state sentence. And Rivera's not happy about that because he's worried about going to the prison there in the Florida system and having threats on his life with different gang rivals and stuff. So we don't know if he's going to still cooperate as he has the last couple trials. He's testified already 3 times. Katie had a mistrial. There was one juror that held out, would not agree to convict her, so they retried her a second time, and she did get convicted the second time. They did a lot better job. The prosecutors did this second go around. So I don't want to get bogged down too much details here, but you guys really should study some other places like that cover the case on YouTube. There's even been 2020 Dateline, that kind of coverage on it. They don't do really good coverage in details, but you can get some kind of the general gist of the case. So here, let's go to the appeal here. Adelson raises 5 claims on appeal. The first is that the trial court erred in denying the motion for a change of venue. During jury selection process, after attempting to select a jury, it became clear that it was not possible to convene a fair and impartial jury because of the extensive pretrial publicity, i.e., because the Tallahassee community was so pervasively exposed to the circumstances of the incident that prejudice, bias, and preconceived opinions were the natural result. They cite a Florida case here, Manning v. State. Notably, prior to jury selection, 54 potential jurors had already formulated an opinion about the guilt or innocence of appellate Adelson's, and 53 of them believed that he was guilty. Okay, so the first one had to do a change of venue denial. Second one, the trial court abuses discretion when it denied appellant motions to strike the veneer panel after several potential jurors reported to the court and other parties that other potential jurors were having conversations together about the case after being instructed not to do so. In fact, there were multiple accounts of potential jurors talking about the case, and some of the jurors who had been discussing the case were the same jurors who held preconceived beliefs that Adelson was guilty, and some of the comments reported were expressions of appellant's guilt. Therefore, the court's refusal to strike the jury veneer, which means like potential jurors to actually sit down and hear the case, was unreasonable based on the record of this case. The third point of error they're raising is that the court erred by precluding the defense from entering text messages that were shown appellant Adelson and his alleged co-conspirators were communicating normally during the first time of the attempt on Dan Markel's life. To rebut the state's contention that appellant Adelson and the alleged co-conspirators were making calls about the murder during the time in question, the excluded text messages intended to establish a reasonable doubt about Adelson's guilt. The state was permitted to show that the phone records occurred between the alleged co-conspirators and to argue that the fact that the alleged co-conspirators were communicating on certain dates show that they were conspiring about or at least discussing the murder. Defense wanted to show the actual substance of the text messages to a jury to negate the state's assertion that these alleged co-conspirators were discussing the murder. The substance of the messages was not, in fact, about the murder, but were about normal things. Fourth, the trial court improperly excluded relevant accepted hearsay evidence that was highly probative to the theory of the defense. In effect, a recorded phone call where appellant made the statement that he had been extorted in the past, and this was not how extortion works. The statement of appellant that this is not how extortion is done or was done is not being offered to prove the truth of the matter asserted is that the extortion was not done the particular way the FBI was doing it. So rather, the statement was being used to show the appellant believed that the police were behind the bump extortion because he had previously been extorted by Dan Markel's killers. And then they argue the cumulative effect. So that's the gist of it here. Let's scroll through this. The trial court's ruling denying the motion for change of venue is reviewed on appeal pursuant to the abuse of discretion. So the appellate court has to look at the trial court's ruling, and if they think the judge abused his discretion, then they could reverse this and send it back for a retrial. So basically, the argument is that both Florida Constitution and the U.S. Constitution protect the defendant's right to a fair trial by an impartial jury. And then they basically say that here the test for determining whether to change of venue is whether the general state of mind of the inhabitants of the community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors cannot possibly put these matters out of their mind and try the case solely on the evidence presented in the courtroom. And then he goes on to say here further down that during the jury selection process, Adelson's case, the trial court interviewed 130 potential jurors one-on-one to assess their knowledge and opinions of the case. Of those interviewed, 96 had heard about the case, and of those who heard about the case, 54 had formed an opinion about it. Of those who formed an opinion about the case, 53 believed Charlie Adelson was guilty. In other words, only the single potential jury who held an opinion of Appellant Scalise's guilt believed he was not guilty or could have been wrongfully charged. During the potential jurors' interviews, the jurors stated that the source of their knowledge about the case included the Tallahassee Democrat, local news broadcasts, cable news specials like 2020 and Dateline, court TV broadcasts, CNN podcasts, YouTube, radio, social media documentaries, neighbors, friends, parents, coworkers, and some who say they had watched the co-conspirators' trials. Yeah, so I covered this on Charlie's trial on YouTube. My brother John was there for some of it. I drove down and watched the closing arguments on this case. And so my brother John actually got to be in part of the one-on-one interviews with jurors. I was not there as a part of that. So what they do is cherry pick certain comments that, like this guy here, several jurors explained the notoriety of the case, and I've been around long enough time in this town long enough to know it, or something like that. Another guy says you have to be living on a rock not to know about it. But you know what? This case is so old; it's lost so much traction in the public consumption there and the media that a lot of people did not know enough about it. So what they go on to show is just these 50-some thought he was guilty or probably guilty. So then they go on. They hired this guy to New York, Mr. Durbin, just to do the jury selection, him and a couple other guys from this firm that I guess specializes in jury selection. Excuse me. Excuse me. And it was really a sight to see. There was a lot of chaos in the court. These attorneys coming and going. Excuse me. Man. And yeah, the case is so old, somebody thought he'd already been convicted. In any event, so what that 50-some thought he was guilty. They got enough, they got 12 and some alternates to not know enough about the case and to form an opinion. And the standard is not whether you have heard about the case. The question is whether you're fixed in your mind about the guilt. So he's talking about all these other ones. Yeah, probably guilty. Everything's pointing to guilt. I think he's guilty. 90%, I think he's guilty. From the podcast, guilty. So you see all these things in italics saying he's guilty. This keep in mind, this is part of the defense motion. This is not a court ruling here. There's more of that. So that Mr. Dubin, that lawyer that's just came in exclusively for jury selection, then argued it should be somewhere in South Florida, somewhere where the Tallahassee Democrat, their local newspaper, doesn't have coverage and their local stations doesn't have coverage. And Ms. Kappelman, she was a lead prosecutor on the case, Georgia Kappelman. She disagreed and said, Your Honor, in less than 2 days, we've got 60 jurors that have passed the test on publicity, and we're ready to go to the next phase. And I wasn't there to listen to all that, but I think, like I say, this case was so old from what my brother had seen about folks that had been interviewed in the jury selection, my brother John, that is. And so I don't think this is a winnable point of error right here. If they all would have said, hey, we've heard some about it and my opinion is fixed, he's guilty, yeah, then they would have been sitting on this case. So the members that they had, the jury members, were adequately cleared, so they don't talk about that. they're just talking about the ones that had heard something about it. So I think it's a losing proposition. See, they cite the Supreme Court case from 1984. The United States Supreme Court held that the relevant question is not whether the community remembered the case or whether the jurors in that case, Youts, the defendant in that case, trial had such a fixed opinion that they could not judge impartially the guilt of the defendant. So then again, going again to talk about the 54 who weren't selected. So it's really a something that's not a credible point of error. But look how much time they spent. The whole thing's like 91 pages, and then they talk about the 12 jurors who actually sat in judgment of Charlie Adelson. 8 had media exposure to the case in some manner, but he doesn't cite their comments here. And then he just cites the overall coverage of this, but then he's arguing that change of venue should have been granted, blah, blah, blah. So anyway, he got a fair trial. The people there might have heard about the case, but they did not form any kind of a fixed opinion. Otherwise, it would have been bounced, not being allowed to sit on the jury. So what some other numbers, 53 out of 54 out of 130 did have fixed opinions, and they were properly excused. So the court, the Honorable Judge Everett, did not do anything to deny Charlie a fair trial. That's my take on it. And then the second party is saying that the judge abused his discretion when it was denied. The defense motion to strike the panel after potential jurors reported to court and parties that other potential jurors were having conversations together about the case after being instructed not to do so. During the individual voir dire process, prospective jurors reported several instances of other prospective jurors discussing the case, which was against the direction of the trial court. So here was prospective jurors talking about what another person back in the jury pool had talked about. And he talked about how Charlie's guilty. And then the Dubin had argued that he moved to strike the panel because he blurted out in an assembly room, in abundance of caution to protect the client's constitutional right, going to move to strike the entire panel. Okay, well, there's a lot of people in the room, so how many would have actually heard some guy just talk about, yeah, he's probably guilty? Somebody said they think all day they were talking about it despite, oops, sorry. We're just talking about it despite the trial court having instructed everyone to not discuss the case. So then they did a motion to strike the entire panel. That was denied by the trial court. And then I guess this juror said that they weren't talking about all day. That was 9 years ago. Then the Kaplan, the prosecutor, said all I heard is that the jurors discussed the fact that this is the case they were here for jury selection on. It occurred 9 years ago. It's like she says that's not enough to warrant that drastic remedy of striking all the jurors. And the judge denied the motion and said he was going to go out there and reiterate not to discuss matters pertaining to the case. And the judge gave another warning. And some other prospective juror mentioned that they had listened to a podcast. asking where it was at. There's other talk about another potential juror hearing stuff. They don't know which one exactly was talking about it. Then the defense asked the judge to get rid of jurors 51 and 102. I think it was meaning inclusive. All of the jurors numbered 51 to 102 should be excluded because they're tainted. So they made the renewed motion again after they heard something else about a juror talking about it. So he's arguing that the fact that discussion did in fact take place indicates an impropriety. So basically they're saying there's based on multiple accounts about potential jurors talking about the case. There should have been a striking. They're saying that removing the jurors who participate in the potential prohibited discussions was proper, didn't cure the problem. So ultimately, they're saying that trial court abuses discretion because it's unreasonable not to strike the panel under specific circumstances. Protection of Adelson's constitutional right to a fair and impartial was requiring the granting of the defense motion to strike jurors 51 through 102, especially in light of the fact that only 13 of them had not already been excused. So they're basically saying he was denied his constitutional right because of that. It doesn't sound like this has merit enough to say there's an abuse of discretion. It looks like the judge tried to exclude those that were identified. Number 3, the trial court erred by precluding the defense from entering text messages that would have shown appellant Adelson and other alleged co-conspirators were communicating normally during the time leading up to Dan Markel's murder, to rebut the state's contention that appellant Adelson and alleged co-conspirators were making phone calls about the murder during the time in question. They cite the authority for admissibility of relevant evidence. And then let's see here. The trial court erred when it precluded defense from entering text messages with Charlie Adelson and the other co-conspirators, Katie, Donna, and Wendy. The trial court, they're saying exclude them based on hearsay, relevance, and confusion of the issues. During this case, state was permitted to introduce call logs and cell tower information, which showed appellant Adelson and Ms. McBannel were communicating directly before the murder, around the time of the murder, and after the murder took place, allowing the state to argue the jury should infer that communication pertaining to the murder. Defense wanted to, in their case in chiefs, sought to introduce text messages to rebut that inference. Defense further argued the text message as a collection of composites showed that appellant Adelson's state of mind was not conspiring to commit a murder. This trial court excluded text messages. I think this issue there about text messages, they want to put the context in them, not for the truth matter asserter, but just to show the normalcy of it all. I think that could have been allowed by the court, but is it going to be a reversible error? I don't think so. Ultimately, defense counsel was permitted to ask Charlie Adelson about text messages. He talked about them being work, personal life. Anything about the first attempted murder in Tallahassee? No, not all. Anything about violence? Not all. Anything about sort of panic? No. Something talks about the right to present a defense. Something I've been saying should be there for Karen Reed, and that the court's rampantly violating that. As a general proposition, any evidence that tends to support defense theory of defense is admissible and is error to exclude it. So they're saying that error in excluding the messages down below here, the last paragraph, was not harmless, as the state cannot meet its burden of proving beyond a reasonable doubt that the error did not contribute to the verdict. The harmless error test places the burden on the state as the beneficiary of the error to prove beyond a reasonable doubt that the error complained of did not contribute to the verdict, or alternatively stated that there is no reasonable possibility that the error contributed to the conviction. I don't think they're going to find that the error contributed to the conviction, if they find it an error at all. There was so much otherwise overwhelming evidence that I don't think the state's going to let them get off on that issue. All right, so I'm just going to jump ahead. So that's how they summed it up. Trial court erred in preventing the defense from introducing the text messages. Then they're talking about number 4, the trial court improperly excluded relevant, accepted hearsay evidence that was highly probative to the theory of the defense. In effect, that recorded phone call where Appellant Adelson made the statement that he had been extorted in the past, and that's not how it works. That was a phone call he had with Donna, who was on a wiretap. The FBI was listening in, and he was trying to convince his mom that that's not how an extortion works. When she got bumped with a newspaper article talking about the murder, and they're saying, hey, you paid, and he mentioned Luis Rivera, Tuto or Tato, whichever one I forget is. Tato was Luis Rivera. So he says, hey, Tuto wants to get paid. So the thing is, the Adelsons didn't know that Luis Rivera hired somebody else to join him up there to do the killing. So it really threw him off. And then Charlie, sure enough, is calling his mom, and or I should say the other way around. Donna calls Charlie to say, hey, you won't believe what happened. We need to talk. Instead of talking in private, Charlie got enough out of her over the phone trying to talk in semi-code that it's so obvious that Donna and him have been a part of this murder plot. The bump is what they call when the cops drop something with a suspect to try to see how they react. It's sort of like a way to turn on the lights and have the roaches scatter. And in scatter, they really did here in this case. See, the next day, Appellant Adelson discussed the matter on a phone call with his mother, Donna Adelson, which the FBI recorded. Defense attempted to move the phone call into evidence as Defense Exhibit 101, but state objection on hearsay grounds. Defense then proffered the recorded phone call. On the phone call, Charlie Adelson asked Donna, his mom, whether Harvey Adelson, the dad, had told her what they spoke about on the recorded call. Charlie told his mom that it's not done like that. It's not. I know for a fact it's not done like that at all. After hearing the proffer, the trial court asked defense counsel the following question. With regards to the hearsay objection, the part that really stuck in my ear was your client saying it's not done like this. What is the qualification to essentially make this opinion if it's not hearsay? Defense counsel responded to Appellant Adelson that had been extorted before by dance killers, and he knows it's not done this way. In effect, the way the FBI was doing it via the bump. The trial court responded, assuming there were many ways to skin a cat beyond the one way which he's alleging to have been extorted, what is his foundation to make this opinion? Defense counsel explained that the opinion is based on Charlie Adelson's past extortion experience. In effect, the theory of the defense that the statement would have been an exception to the hearsay rule because it was offered to establish Adelson's state of mind at the time of the call. Despite this explanation, the trial court sustained the hearsay objection and did not allow the admission of the phone call into evidence. For the reasons set forth below, the trial court's ruling was erroneous. And it goes on here. So then they're offered it again. This is not done to prove the truth of the matter asserted, but rather a state of mind. So hearsay, there's a lot of exceptions to hearsay, and one of the things is not offered to prove the truth of the matter asserted. The definition of hearsay is an out-of-court statement offered to prove the truth of the matter asserted. So the defense is trying to say, like, the trial court messed up by not allowing us to present this statement of Charlie into evidence because we're not trying to prove, in fact, he had been extorted. It just shows his state of mind. But they really are trying to show that that's how that he was extorted in the past, i.e., he's trying to say it was done by the hitmen, but the idea of the extortion hadn't even been plotted at that time yet, I don't believe. All right, so they're saying the state cannot prove that was harmless beyond a reasonable doubt. Then they're saying the cumulative error, combination of all these, denied him a fair and impartial jury. And they want to have the conviction set aside and remanded with instructions to conduct a new trial at the trial court level. So that's it for there. Y'all have any questions from that before I go on to Donna? Yeah, Corey says, of course, they denied all the code words. That's true. The code words, they did talk a lot in code surrounding the time, especially when Dan Markel was murdered. Other half dozen, that's true. No one else would have known Dan's route that day besides Wendy. If you guys go back and look at the Charlie's trial, it's on YouTube. I covered it also if you want to see it on this channel. I think I covered it from after day one. So I covered day 2 on. And then I actually sat in there during the closing, so I did not cover that live. John and I were watching the closings together in person. But Monique, you're saying the children are now still with their mom and somewhere in the Austin area, Austin, Texas. Yeah, I also did, if you go to this channel, if you're not familiar with the case, there's indicators of Wendy's involvement I did initially, and then there's a more advanced one that I did where I did more of a deep dive on that. And I actually should probably cover that here because I did it on another channel where they had me on as a guest on Survivor. So I never actually did post that on this channel because I actually didn't even have a channel then. Yeah. We'd not set up a channel yet. Danielle X, you're saying you thought the Markel murder was most difficult to explain in case until you covered Karen Reed and Richard Allen. I'm not familiar with Richard Allen, but yeah, True Blue, you're asking what will happen to the lawyers. It was found that they let Donna use their phones, watch call Harvey during their prison visit at Leon. All right, I'm going to get to that here in a minute. Let me see something. There's not actually court filings that talk about it because it sounds like the cameras were not involved and they allowed in the court. But we'll go to a link here that talks about it. Stand by here. So think about it. Donna got arrested November of 23. Like I say, less than a week after Charlie got convicted of murder of Dan Markel. She got brought up the exact same murder charges. And so their eldest son, Harvey and Donna's eldest son, Dr. Robert Adelson, apparently there's a plot discussed in court in a hearing in April about a plot to kill him that Donna was trying to convey to Harvey to execute. So hold on a second, 225. Stand by a second here. So I don't think that appeal will be granted at all. I think it'll be dismissed without any correction. So here's just a short clip talking about on court TV what they had observed in the trial, in the hearing and back in April, I believe it was. So stand by.
In forefront, and now we're hearing that there are these new wiretaps that the defense is just getting to listen to. They're talking about hundreds of calls. And more than that, the defense is alleging that the state recorded conversations between Harvey and a jailhouse informant. They're alleging that the state is making up conversations because apparently the state is alleging that Donna's new attorneys that were entered after there was a prior conflict of counsel have been helping her to communicate with Harvey using their own cell phones and watches.
Okay, so that's really serious. So that's what you're just alluding to here, True Blue. So these are Donna's new lawyers. That's Zellman here. That's the guy on the right here. Then you see Donna Adelson in the middle with the glasses. And then you see her attorney on the left here, Fulford. She used to be a judge there, but then was forced off the bench by the State Judicial Review Council. And so anyway, she's been in private practice doing criminal defense. And so Donna had to spend probably, I don't know, another $1 million plus to hire these two people after she'd already hired Dan Roshbaum, who was the losing attorney representing Charlie. So I don't know why Adelson's would hire a lawyer that had lost with Charlie, and now he's representing Donna. And I was saying all the time it was a conflict of interest. The judge had not screened off this conflict. It's really a conflict that denies someone a constitutional right to conflict-free counsel, because that's something that Supreme Court case law has decided many years and many cases ago, that you have a constitutional right to conflict-free counsel. And if the conflict is even something that's so pervasive and serious, even the defendant can't waive it. So anyway, this was not properly brought up during Donna's period where she was in the jail for a year awaiting trial. And so they had a brief summary hearing on the record where the judge asked her 7 questions about conflicts and does she waive them all. She said yes, but I always said that wasn't enough of a cure. And because her attorney, whose name was Daniel Roshbaum, he represented Donna way back till like 2016, from 2016 until just less than a year ago, when he got bounced off the case. And he went from going from Donna to Charlie, representing him all the way through trial, then back to Donna. And I was just saying all along that this is like such a huge, reckless thing to do as a defense lawyer, because you're basically setting yourself up to be in the dilemma of which client do you have the most loyalty to. And if there's a question of loyalty, what if Donna wants to plead guilty and discuss making a plea of guilty, because Charlie was also his lawyer. Dan Roshbaum was Charlie's lawyer as well. He automatically could not discuss a plea agreement of either one of them. So that's really the dilemma we had here. So if we have a lawyer these two lawyers are using devices to allow her to communicate with Harvey. Number one, the jail would never allow that. So that'd be violating jail rules. But Harvey then is on a wiretap and making, well, let's hear it.
And it is during one of those conversations, allegedly, that there was a discussion about a potential plot to harm their eldest son, Robert, who is estranged from the family.
So right there's Harvey on the right, and there's Donna back before she got arrested. Look how different she looks now.
Oh my, Lauren, you weren't kidding. This is quite a web here. Tommy Pope, so let me go to you next, please. So the defense, he wants to depose 2 investigators that were involved in the wiretaps, as well as Robert Adelson. Now, specific to Robert, they want to know about how some new accusations could impact his testimony against his mom. Judge Everett agreed that if the defense has some new questions not previously asked or some new information, the witnesses can be deposed on that. Otherwise, he'll take the issue under consideration. We've heard Donna before on jailhouse calls with her son Charlie as she talks about going to Vietnam. I have a clip for you here, Tommy. Let's take a listen together.
The other thing I don't understand, my daughter could help me with, but we've been looking it up over and over, because things change. It's extradition from Vietnam, because we've looked at all the places. I mean, I could go to Korea and China, but there's no extradition. But we're looking for.
So there's Charlie, a photo of Charlie. So keep in mind, after he got convicted, there's all these phone calls that they were recording between Charlie and mostly Donna, but also Harvey's in the background on and making some comments as well. But they were right away scrambling to go to flee the country. Donna and Harvey were. So it was something that they're going to live to regret, because that's going to come out at a trial here. It's consciousness of guilt if you try to flee while you're pending law enforcement pursuit. Anyway, that's all we have on that. There's no other court things that are noted and court filings to note this kind of thing. But I'm telling you, if defense lawyers are allowing Harvey to communicate with Donna, and then she's talking about putting a hurt on Katie McBanois, putting a hurt on their oldest son, Robert Adelson, and also killing the mother of a jailhouse informant that was informing against the police against things Donna had said to her. This is like really, really explosive and crazy kind of stuff going on here. So I'm wondering if these new lawyers have a conflict as well. So this may not survive appeal scrutiny when you have lawyers that are engaging in communicating with outsiders and they're subject to FBI wiretaps, and you get information or talking about putting hurts on witnesses. I can't believe attorneys would be sitting there listening to all this. So what, did they leave the room or something? None of this makes any sense, but you can't make this stuff up. It's so crazy. Yeah, so Luis Rivera, who drove the hitman vehicle up to Tallahassee, he's getting out in 6 years of state prison. And the thing is, with good time credit and stuff like that, is even going to be a year that he spends time there. He could be out in real short order. I'm not sure how that works. When he was served concurrent sentences between the state and feds, I believe it was. So he has to do all the Fed time first before he starts the state. But the state one, a lot of states, you can do like a quarter or less of the time that you're sentenced to. You get out with parole, early parole, good time credits. Now, the children aren't going to have to testify, Monique. I don't think the prosecutor, they're too young to know what was going on. They were only like 3 and 4 or 4 and 5 at the time. But I'm sure they'd have things to say about how their mothers reacted about this whole thing. So now I'm going to go back here. Yeah, if you guys want to listen to the calls, the best recording was forget her name, Pretty Lies and Alibis. That's the name of her YouTube channel. She's got really good recordings, and she also has the closed captions underneath. Now, let me find that for you here real quick. Pretty lies and alibis. And let's see here. I'm not finding any of Charlie's phone calls right off the top here, but anyway, you guys can find it. But yeah, there's a lot of hours of really, really amazing things. Charlie's talking about how he's blaming the jurors there up in Tallahassee being low IQ, low intelligence, they're only like fourth graders. Yep. All right, so I'm going to cover some of the most. So we got trial coming up in August here with this whole issue about the lawyers being involved with helping communication between Donna and Harvey, her husband. Excuse me. All right, so let's see here. There was an effort to at the last trial for Charlie Adelson, they had Dan Markel's attorney, Stephen Webster, testify. Okay, I got Leo the cat here crying. He's already been fed, so I don't know what you want. Let's see here. I'm going to add this. Okay. Want to remove that? Gosh. Okay, here's the one on Stephen Webster. So keep in mind, this is Dan Markel, Professor Dan Markel's a lawyer at the time, and he did a great job of testifying. He explained how this was a really contentious divorce. He thought Dan had been railroaded by Wendy, who was flagrantly violating the terms and conditions of the divorce on visitation. There's testimony about and allegations that Donna Adelson was telling the two young boys that their father's stupid and other things like that. So they're trying to keep him out here, saying he's not relevant. He doesn't have enough details. Here you can see here, top of the page here, number 7, Mr. Webster's testimony senators on what Mr. Markel said to him about the post-dissolution, which means divorce proceedings, including that Mr. Markel had said he heard Mrs. Adelson say stupid is on the phone. So she referred to Dan Markel as stupid, referring to the boys. Sometime after the 26 March 2014 counter motion was filed, he offered his opinion about the strengths of the Markel claims in the custody battle, and then about the involvement about the Adelson's family and his death, his continued advocacy for the Markel family, vis-a-vis participating in podcasts and interviews with media concerning Dan Markel's love for his children and providing commentary about the case. Yeah, this guy's a really, really rock solid attorney. He's really highly credible, and he speaks really well about Dan Markel. And he normally does criminal defense, but he's willing to do family law because there wasn't many family law attorneys left in the town that were willing to take the case because there was a number of conflicts involved. So anyway, here he is trying to get him kept out because they're saying he shouldn't be talking about the strength of Dan Markel's pleadings, but also goes to the state of mind of Dan Markel So I think it's highly probative and relevant. I think it should be admitted. They know it's hurtful to defense. That's why they want to keep it out. All right, here's Leo. All right, let me find this other. This other one had to do with a former friend of Wendy Adelson. It's loading right now. So this one here has to do with the defense trying to exclude Sarah Youssef as a witness for the prosecution. So it says here she's listed as a material witness for the prosecution. She's a former close friend of Ms. Adelson's daughter, Wendy Adelson. Sarah and Wendy met when they first were students at the University of Miami Law School in 2003. According to Sarah, her friendship with Wendy was very close. They were friends for about 13 years. And it goes on to state that Sarah said she was aware that it was a highly contentious divorce and further testified that Wendy emailed her some of the motions Dan filed. Sarah described a birthday party she attended for Wendy's eldest son, which was held at the parents' condo in 2014, shortly after the murder. Well, according to Sarah, while at the party, she overheard Donna say, "They're talking about him like he's a beloved professor. You know something? He was a jerk." This is what she's talking about to her somebody that's just murdered, and that person murdered is the father of her two grandchildren. Unbelievable. Sarah thought that what Donna said was abnormal because Dana just died. In most cultures, we don't speak ill about the dead. In Sarah's opinion, Donna's statement conveyed an outsized and inappropriate anger, considering Dan would never bother anyone again, i.e., he was murdered. Yeah, of course he wouldn't. So that's really the only thing she had to say, other than the fact she had come to the conclusion that Donna was guilty, along with Charlie and Wendy, of conspiracy to commit murder and soliciting someone to kill Dan. So that's the other pending motion. She also said that after trial last year, she saw Phil Markel's victim impact statement and brought her to tears because he talks about how he's been denied so much access to his grandsons. It's really gut wrenching. She also explained that the amount of time he talked about grandparent alienation and not having a meaningful relationship with the children really made her feel awful. Because of this, Sarah contacted the Markel's attorney and provided him with the information he had about grandparent visitation legislation. By the way, there's a actual state law that passed, the Markel Visitation Act, basically grants grandparents visitation rights if their son or daughter has been murdered, and the party that committed it was another family member who has custody of the surviving children. So they're basically trying to say there's not relevant evidence, just saying he was a jerk. But it does go to state of mind and the hatred. The amount of unmitigated hatred on this case is really, really something you don't see in many cases, to actually punish the surviving kids this way. All right, let's see here. There was also a motion to accuse Judge Everett. Judge Everett, if you compare him to what we have up in Massachusetts, unbelievable. So let me pull that one here. All right, so here we have the motion to recuse the judge. Let me split the screen. All right, here they're trying to say that Judge Everett engaged in ex parte, meaning with one of the parties not present, which is against normal judicial requirements, is that you don't hear one side without the other side being present. It just doesn't have the proper appearances of neutrality of a judge. And, but the thing is, what they don't talk about is this had to do with, authorizing search warrants. So they blocked this out here. I don't know what he is crying about. So basically, it was authorizing search warrants for Harvey's cellular phone. They're trying to say should have notified the opposing counsel that he's authorizing that. So they're talking about other search warrants. They're saying they could have used a different judge. But if he's doing search warrants, that's all it is. There's no duty to notify those sides. So I just don't think this motion should go anywhere, and the judge denied it. So with that, yeah, can you imagine if Judge Everett was on the bench on a Karen Reed case? My gosh. Unreal difference. So, all right. So this motion was denied. I don't need to show you the order denying it. Yeah, but what was really bizarre about this whole case is that there was not a lot of talk about Wendy, and that was really making it sound like she was not involved with this. And so that's why I thought it was important to jump in the discussion and actually go through the evidence and look to see the amount of involvement she had. So there's been a lot of chaos with Donna Adelson. She's now 75, locked up in the jail cell there. She's been recently transferred, we found out this past week, to Wakulla, which is one of the places Charlie was. So she's not in Leon County Jail anymore, which is where the Leon County Courthouse is, where Charlie was tried and convicted, and she'll be tried and convicted there as well. That's my prediction anyway. And so we have 2 hearings this week. The first one is a case management conference. That's this Wednesday on the 11th. And there's going to be a motion to change venue. That's going to be on this Friday at 9 o'clock. So I don't think the judge is going to grant that motion to change the venue, because they're going to be able to find enough folks that don't know enough about this case. There's really not that much discussion about the case among many circles there in Tallahassee. And like I say, it's going on 11 years old. Yeah, Reverend Burgess could have almost gotten a BS degree. It's time it's taken for get justice for Dan's parents. Yeah, Jolie's, you're saying Wendy was a ringleader. She complained to her mom about Dan. Yeah, Donna's emails to Wendy were really, really egregious. She was talking about dressing up the kids as Hitler Youth to try to get Dan mad and say you're going to change the kids' religion if you don't let me move to South Florida. Yeah, and Wendy had driven by Dan's house just over an hour after the murder happened, and it was way out of the way, and she's basically saying she was going to pick up some liquor for a party. So, and then she keeps changing her story of how far and close she got to the house. So it's one of the things that the prosecutor really drove home to show this was a family type function to get Dan and Markel murdered. And when you listen to the jailhouse calls, Dan goes over and Charlie goes over and over again talking about how, what are the odds Wendy would be going by shortly after the murder, that house, going completely out of the way to get some bourbon that was easily found at many other liquor stores much closer. Yeah, this is a good one. If you haven't seen the video talking about the absolute absurdity of Wendy's choice of liquor store as well as the route she took to get there, look it up. It's the How's Long to Die in the Cold of case. Sarah, True Blue, you're saying that Sarah said that Wendy said, I'm going to jail for the rest of my life. Yes, the other thing is that these hitmen coming up from South Miami, they had to know Dan's schedule to be able to conduct the murder, and the boys weren't going to be there, obviously. So it was most convenient to have it happen when the boys are dropped off. That way, it looks like, well, what kind of person would Wendy be if she was having hitmen come up from Florida during the time that they're with their dad? So obviously they're not with the dad. He just dropped the kids off, went to the gym, and came home, and that's when he was gunned down. Yeah, and the crime scene tape you mentioned here, Ellie Woods was at Dan's house. So she came by when the cops had already responded, and the ambulance and all that, and crime scene folks. And they had not even removed, like there's like I don't know, 10 or so cars there, and she hightails it out of there. So you know your kids are staying overnight there, your two boys, and you see it's a massive crime scene, and she hightails it out of there. So sorry, that's a real indicator of consciousness of guilt. Excuse me. Yeah, Danielle X, you're saying your personal hypothesis remains that she was supposed to stumble across his body because the neighbors were never expected to hear the shots and nobody would have been home in the neighborhood to hear. Yeah, that is a theory that some people have thought of, and it could be true. The thing is, I don't think that at any point was it discussed that she was supposed to go over there at all. I think that was maybe her own ideas. I just don't think the way Charlie's acting is that he thought that she was going to mess it up by going over there, because his complaint was, what are the odds? It's like he said, a friend of his in Detroit said it's 1 in a million that you pick that day and time to go over to a house for something you don't need to be going over clear across town to get. And so if she looks guilty doing that, then she makes the rest of the family look guilty as well. Yeah, but she said all that crime scene tape had to do with a fallen tree. Yeah, right. One of the things I don't do about the Adelson case is talk about defense strategies, because I don't want to help them out. If I think what they will do, then maybe they'll tweak something. So I think it is going to be, they're locked in. I can say this, they're locked into what Charlie said has happened. If she tries to backtrack off that, it's just not going to fly based on what they got her on the wiretaps. You guys need to listen to the FBI wiretaps between Charlie and Donna. It's really, really incredible. You can just tell it's just dripping with guilt the way they talk. They just couldn't help themselves but not talk about it in private. They even told Harvey and Charlie go into a restaurant and they try to have parabolic mics picking up their conversation. They got some of it, but it wasn't that great. Yeah, you guys, the real hero of the case is Jeff Lacasse, professor, PhD now. He described how Wendy was acting so strange leading up to the date of the murder. And he's the one that really explained it to the cops what was going on in the family dynamics. And the local cops here just weren't smart enough to listen to him initially. Took him a couple years to catch on. But boy, was he dead on accurate. Yeah, Lacasse dated Wendy. Yeah, really. Yeah, Jeff Lacasse was sort of like the Karen Reed, but he got out of town. Unlike Karen, who went back to 34 Fairview. Yeah, in the interview, I think you're talking about in Canine Lover, Wendy was just playing innocent. Who, me? She's letting her brother and mother go down, and there's no one that will convince me she was not involved. Every time you look at the interview, at least in the first 45 minutes, you'll see more and more indicators of her reaction is just not normal to learning. She learned in the interview that Dan Markell, the father of her children, has been shot. So with Donna's trial starting in August, supposed to be around the 19th of August, there's something that I'm concerned about that it may get bounced because of the conflict of the attorneys. I don't think the attorneys are going to raise a conflict among themselves, but I think the prosecutor and the judge need to look at them. That's what I think should be happening if this case was in Texas. If I was a prosecutor, I'd be looking at what's this issue about these details about the lawyers helping Donna put out hits on people and using their phones. If that's what's really this is about, then I think we got another attorney conflict issue. Moto 88, you're saying Microdots does a great job of showing Wendy's route. I don't think they're on this case, are they? Microdots was on last night's channel, and I asked him to, me or somebody else asked him to cover this case, and I think they said they would consider it after this case is over with Karen Reed. Yeah, it really looked like they're trying to frame Jeff Lacasse. He's like a awesome guy, super likable, high character guy. Yeah, in light, his interviews were excellent. He was right about a lot, worth watching for sure. Everyone was endeared to Jeff, honest, good guy. Yeah, he's the key to prosecuting Wendy, that's for sure. But he really really sets the dynamics up well with how the family wanted Dan Markel eliminated. S3 201, 2021. How does a defense lawyer defend someone they know is guilty, or do they agree to be a defense lawyer if they know they're guilty? It's one of those deals where, as a defense lawyer, there's a constitutional right to it. If you look at it from the standpoint of you're presumed innocent until the government can prove the case beyond reasonable doubt, then the person should remain free, and until and only if there's a conviction by a court of law, either by judge or jury, at the election of the defendant, until and only then they are not guilty. So I think the way I look at it, and probably most defense attorneys look at it, is it's like a legal game, a chess game, and your job is to defend your client. Justice is better when you do have aggressive, tough attorneys that know their job and they hold the government's feet to the fire, hold them accountable. Because if the government can resort to sloppy techniques and just basically arrest somebody and not try to prove their case with sufficient evidence, and they botch the crime scene, and they bring a bunch of liars up to say somebody's guilty. If you don't have a good attorney that's to cross-examine them, then you can easily have guilty people get convicted. So I don't look at it so much as when I'm interviewing my client, is like I just say, tell me your story and write it all down. Write me your whole personal history. I really got to know what you were thinking about, what led up to that certain incident in question, and then based on that, I look at the evidence and I sort of see if we have a case or not, if they can prove the case or not. So I don't really have a discussion up front with whether they're guilty or not, unless it's out in the open, or they come out and tell me that they want to plead guilty and cut a deal. So the ones that usually go to trial, they never tell you up front that they want to cut a deal. You wind up not really getting that discussion until you really realize you're going to lose the case, and then you have that discussion with them. Or I guess I should say I'll discuss that with them if they want to have that option. But you got to be really have the right instincts. I don't want you to bring up plea agreements with a client that wants to go contested the whole time, because they may lose faith and confidence in you as a lawyer if you start pushing a plea agreement. So that's why I look at it as you're just holding the system's check and balances in place. And it's a constitutional issue at that. Yep, that's right, CT girl. Because think about it, if you didn't have defense lawyers, I've always said you could have a bad judge, you could have a bad prosecutor, a bad defense lawyer, a bad cop, and bad jurors. Any combination of that, and you can get convicted easily. Or just a bad witness, I should say, as well. Somebody making up lies about the defendant. C-Rock, you're saying, is it possible to delay Donna cause by having the same lawyer as Charlie wasn't intentional in order to delay the heat turned on Donna? I think they acted for the good of the family. I think that this was not intentional by the Adelsons. I can't imagine that the Rashomon, the defense lawyer, didn't realize that he was setting him up for an appeal. I think most lawyers don't understand criminal conflicts of interest because it's a constitutional issue. Civil lawyers, they can waive conflicts all the time, and they do waive them all the time. But for criminal law, it's a much more of a serious issue because the Constitution is involved. True Blue, if the lawyers were helping Donna, would they be conflicted out, disbarred, charged with felony? I would say that I'm not going to talk about them doing any criminal acts. That's a serious thing to say against an attorney. But I would just say that there is a potential of them being conflicted if some kind of use of their phones happened while they were there sitting. If they were there sitting with Donna in the cell while she's making calls, the appearances of impropriety, if that happened, are pretty bad. Where I think that the prosecutor and the judge need to look into that, because we may not have a trial in August. Yeah, they still need to go after more Adelsons. They still need to go after Wendy. They also need to go after Harvey. Harvey's already 80 now. Peaky Doo, you're saying at least Ken Reed could lodge a vigorous defense. Had they pinned it on Lucky, he'd be in a cell. An upsetting thought. Well, I think with Lucky, he could have said, well, I didn't see a body there. Why would I think a body's laying right alongside the road there with snow on top of it? I didn't see him. So he'd have been cleared. Think about the guilt he would have felt, though. He would have been shook up for life. If he thought he was the one that killed somebody that's laying on the side of the road passed out. Yes, dubious dragon, a defense lawyer upholds the government to a high standard. Yeah, that's why we have jury trials, because we don't trust prosecutors and judges to make the right calls. 12 jurors helps purge the case of politics. But like Massachusetts, they try to undo that by having the judge pick the foreperson. The Caps, Don's still trying to put out hits from the jail. I mean, she hasn't learned any culpability for Dan's murder. Yeah, microdots, Jim, check it out. Just Google microdots on YouTube. Do a YouTube search, I should say. They do a lot of good videos on the Karen Reed case. Excellent, top-notch quality, really impressive work. I just showed a clip of microdots last night. So go to my last live stream last night. Yeah, that was brought up in court, Surge Deb. So Donna was moved to the different facilities so she can have more access with her tablet. I don't know if it's an iPad or what it is, but she needs to be able to look over documents for trial. So that's why they moved her. So she's about 25 minutes south of Tallahassee at a different state facility. Daniel X, you're saying do not look at the Richard Allen case until Karen Reed's resolved. Both are detrimental to one's mental health. Yikes. Yeah, there's 2 channels. Thank you, Microdots and Microdots Clips. Yeah, so there's not going to be anything on the case management hearing on Wednesday, so I'll just say something about it on Friday at some point. The change of venue. The judge probably will not issue a ruling right there from the bench. He'll probably give a written opinion sometime in the next week. So I think they need to run ground this conflict issue. They never ran the conflict issue down on the ground sufficiently with Charlie Adelson when he went to trial. The judge didn't know that Rashmon had been representing Donna for multiple years before Charlie's arrest. The state did, and the state should have known that. Rashmon jumping from Donna to Charlie would be a problem for Charlie, especially if they plan on subsequently prosecuting Donna. So you guys are saying the judge and Richard Allen's even worse? Wow. All right, so it's we're going on an hour and 31 here, so I'm going to go ahead and shut it off for tonight. But tomorrow's Monday, another day back in Denham, Massachusetts for the Karen Reed case. We're going to hear from the rest of the testimony from ARCA. May not be done tomorrow, may cover spill over into second day on Tuesday because the second ARCA witness hasn't started yet, but defense is on a roll, and I think they're going to close it up, like they say, by Tuesday, and then hopefully the state will not drag this thing out. Hopefully their rebuttal will be very short and won't be painful to watch. So with that, I'm going to go ahead and sign off tonight. Thanks for all your support for justice for the Markells and also justice for Karen Reed and her family. Hope to see you all tomorrow night. Thank you much, Food is Love, for your mod tonight. Appreciate you. And you guys check out more of this Adelson case. You can't believe it. It's really mind-boggling.